Thank you very much there. So the draft new constitution was released last year, and there is a lot of excitement around this very vital document. So today I have in the studio Mr. Lamin J. Darboe. Mr. Darboe is a UK and US educated or trained lawyer. He's an expert on constitutional matters. He's also the founder of Dabanani Law Center of Sukuta. Mr. Darboe, thank you very much for coming to our studios today, Barrister.
I'm glad to be here.
Barrister, I am sure you heard or you must have seen the new draft constitution there. But before we get to the new draft constitution, I want to ask you as an expert on constitutional matters, what is a constitution?
Well, constitution is the fundamental law of a country. You have statutory law, which is of a lower category than constitutional law. Constitution is at the very top, yes, if you like. So constitutional law allocates public power, state power, to different branches of the government. And those branches of the government traditionally are the legislature, the lawmaking function, the executive, the law implementing function, and the courts, the judiciary, the law interpreting function.
So why a constitution?
Well, every organization must have its rules. So if you like, the constitution is the top rule of any country. So it sits at the very top. And it is what we rely on, what we use, yes, to administer the affairs of a country. So really, like I said, you take a constitution and allocate it to these three arms of government, the three branches, the judiciary, the legislature, the executive. But also, a constitution cannot be complete unless you have the protections that must be in any constitution of the rights of the citizens. Because government rules not over animals but over human beings. So they have rights which are protected in any constitution, at least any democratic constitution, let us put it that way.
So then let's get started then. The new draft constitution. What is your assessment of it?
Well, I went through it, the whole document, from the beginning to the end. And one thing I can say is that some improvements have been made. Say, for example, if you take the control of the executive over yes, the legislature, yes, that has been improved tremendously. If you take the control of the executive over the judiciary, that also has improved tremendously. And the executive itself is restrained in key ways, so that the ability that the 1997 Constitution gave to the President, the executive, to do things that are not in accordance with the Constitution itself, to remove members of the judiciary without going through the proper processes, to remove even National Assembly members without going through the proper processes. They have all been improved somewhat. But really, the Constitution, I believe, is still very, very bulky. There are parts of the Constitution that really do not belong to a fundamental document, yes, like the Constitution. For example, there is a section there on culture and values. There is a section there on integrity and leadership. Those are not constitutional issues. They should not be in the Constitution. And I hope that Constitutional Review Commission would listen to what the people have to say about this draft Constitution and do what it needs to do in the interest of the country. But it is our right, really, yes, to bring our concerns to the fore and yes, debate the issues. Yes. The Constitutional Review Commission is saying, send your comments to me. No, we have to send, we may send our comments to them, But we have to discuss this in the public space, because it is the Gambia we are talking about, not the Constitutional Review Commission, not its members. The country, that is what we are talking about. So it's okay to send suggestions to them, but I am saying that we should discuss this in the public space, increase the pressure, if you like, on the Constitutional Review Commission to change where it must change.
So now let's talk about let's talk about the building of a constitution itself, the processes. What are some of the processes employed? What are the terms and conditions of building such a very important document?
Well, the process is really very simple. Like I said, it's about power allocation. So you allocate the power. That is the basic fundamental structure. You allocate the power to the different arms of government. You must do that. If that is not done, then you don't have a constitution. All these co-equal branches of government, of course, you would know, obviously, that the executive, because of its dominance in the whole structure, does have a lot of power. But according to constitutional theory and practice and principle, really is the three branches of government that ought to share power. So we call that separation of power. So you have to allocate power to the three branches of government and ensure that they stay within the parameters of their responsibilities. Here, of course, you talk about process also. Well, the Constitutional Review Commission Act actually empowered the Constitutional Review Commission to start the process of getting the Gambia a new constitution. When I say getting the Gambia a new constitution, obviously the name is misleading. It says a review commission. So which means other people may think it's reviewing the 1997 constitution. But that is not their remit as such. They can review and they can bring in, they can import other ideas that are not in that commission, in that constitution, the 1997 one, and they can remove. So in other words, even if they gave us a completely new constitution, that falls within their mandate.
Yes. Okay, so now, and it would appear that the people are quite central to the building of a constitution, since it is the very people. You talked about the allocation of power, separating power between the three arms or branches of government. But then the people are it is the stakeholder that really matter, because you go to people, it is the very people who give suggestions regarding how that is done.
Well, that is true. Okay, I think generally the country would agree that we don't want lifetime presidencies. So we don't want presidents staying in power indefinitely. So definitely if you go to communities, they would tell you that we don't want presidents to remain in power. So that is why we now have the 2 terms limit in the Constitution. And that is excellent. I am very, very supportive of that. Yes. But you look at it, if you say the people, the consultation is okay. But these constitutions are deep documents. You can go to the people and they wouldn't even understand what you are talking about. You can go to the people and they wouldn't tell you to include things that are includable. They'll tell you to include things in the Constitution that are not includable in the Constitution. So what do you do? Yes. So you can consult people, obviously. But at the end of the day, we know how constitutions are drafted. Yes, if you follow the direction of the people to an extent that you gave us a document that is not a constitution, then you are not serving yourself, you are not serving the interests of the people either. So you consult and take cognizance of your own ideas, your own understanding of how a political space ought to be organized. And that really is what constitution making is about, how you organize the public space.
So now let me ask you then, how does this new draft document, the new draft constitution, compare with our current constitution, for example, the 1997 constitution? You've talked about improvement, but how does it compare?
In terms
specifically in terms of the lives of the people, for example, how does it compare? Is it for the good or for the bad?
I think obviously it is for the good of the people. It's better, like I said. It's far better than the 1997 Constitution. But I believe, you asked me to assess it, I believe that the document itself is too long because they put a lot of things in the Constitution that are unnecessary. You don't need to put them in the Constitution. The Constitution is about fundamental principles, the values of a society. The reason why we have the courts is because they're empowered legally with the mandate of interpreting the Constitution. So we don't want a Constitutional Review Commission that is prescribing things for the National Assembly, prescribing things for the courts in the Constitution. For example, if you say freedom of expression, you don't need to then go and say, but you don't need to insult people. You don't need to use abusive language. You don't need to create all these languages that would be very insulting to people. You don't need to do that. Just say the people shall have a right to freedom of expression.
Yes.
The courts are aware of the limits. Yes.
No, it would be left to the courts to interpret.
Certainly, that is the function of the courts. Because you don't, one thing I need to clarify is this. We need to be careful about transient majorities. Transient meaning majorities as of now. Because if you take the current government, it is a transient majority. It will go one day.
Yes.
If you take the Constitutional Review Commission, okay, you can say, but it's made up of not more than 20 people. The commissioners are less than that.
Yes.
Yes, I agree. But they're a majority. Because today,
yes,
they've given us a document. And that document, we need to really engage them. We don't want this document as it is. It is too long, it is too bulky. There are too many unnecessary parts.
That needs to be scrapped.
Yes.
Because I mean, that is one thing that a lot of Gambians also talked about, the issue of increasing the number of chapters from 17 to 20.
Yes, the chapters were increased, but some sections of the Constitution were dropped. So it is 173 pages. But those 173 pages, I believe, are still less than the number of pages in the 1997 Constitution.
Yes.
So I think even on the size, some improvement has been made. But to be honest with you, it is my contention that the Constitution is still too bulky. What will the courts be doing if the Constitutional Review Commission is telling us what needs to be done, say, under the fundamental freedoms? We don't need that.
We don't need that.
Yes. Well, these are things I call the clawback clauses. Okay, the people have a right to freedom of expression, but you should not insult, you should respect the rights of other people. That is not for them. The rights of other people can be addressed by those other people and by the courts. What do you do if somebody speak something about you that is untrue, write something about you that is untrue? You take them to court. But you don't want Big Brother or Big Father, the government, coming and saying, no, we wouldn't allow you to insult people. Freedom is the future. The human being itself is enmeshed with the value of freedom. So if you want to control people, it will not work.
It won't work.
Yeah. Let them do what they want to do, and if there are consequences to pay, well, they can deal with those consequences. But I'll tell you, say for example, the courts, from the magistrates' courts, today, every sitting magistrate in this country has a law degree.
Yes.
Yes. Some of them have not gone to the bar, but they all have a law degree. So they understand the basic principles.
Yes.
But if you go to the superior courts, the High Court, the Court of Appeal, and the Supreme Court, those are seasoned intellectuals. Yes. If people want to do injustice, they can do it. But it's not because they don't know what is right and what is wrong. So leave it to them to decide.
So now we will go into the nitty-gritty of this new draft constitution there. What I want to ask you before we move forward, is it normal at all for a country to be every now and then building a new constitution? This is the third time the Gambia is building a new constitution. In 1970, we had a constitution, and then in 1997, and here we are again, a new constitution. So is it normal for whenever a government comes into office, there ought to be a new constitution? Is that normal at all?
That is why I say we should be ready to deal with our transient majorities. These are our governments. So when I say majorities, I'm not talking about the number of people that is following a particular political party. Those are majorities, but there are different kinds of majorities. Transient majorities are the governments in power, the agencies they set up, the institutions they build. If those governments themselves are not behaving properly, their institutions are not behaving properly, they are going to give us documents that are not properly drafted. Say, for example, say 1997 Constitution. You know, it was a case of being present at the creation. You want to remain in power indefinitely. So you drafted a constitution that suited your personal ambitions, but it's really not about the future of your country. So that is the problem. Take a country like the United States, 1789, 240 years, 230 years, that constitution.
It's the same constitution.
It's the same constitution, and it's amended only 17 times. 17 times.
17 times.
In 230 years. Because the
and these are just particular parts
exactly.
of the constitution.
Yes. Yeah. Right. It was a document for the people. When the founders were creating that constitution, they were creating it for themselves and for posterity. But here we create it for ourselves.
Or would one be right to say we create it for government, or government creates it for itself?
You are absolutely right. I said 17 amendments. So some people listening may say, no, but it's 27 amendments. The first 10 amendments of the U.S. Constitution are coextensive with the actual document itself. They just call it amendments for ease of reference because they deal with the Bill of Rights, the rights of Americans.
Yes.
Yeah. So the Bill of Rights tells the government what it cannot do. Yes. You cannot set up a religious establishment.
Yes.
You cannot muscle the press. But if they say muscle the press, they don't mean the press is free to do whatever it wants.
Well, yeah, it comes with responsibility.
Exactly.
Yes.
It comes with responsibility, but that responsibility is not for government. If government believes the press, a particular...
has done something wrong.
Yes, a particular newspaper or broadcasting house did something wrong, all you have to do is take action. The courts will decide. The courts will decide, yes. Yeah. So yes, there is no absolutism there, and we are not advocating absolutism in our fundamental freedoms.
Yes.
All we are saying is that governments must leave these documents to the courts to interpret. Must leave these rights to the courts to interpret. That is imperative. We have to do that. So that is the reason, because constitutions are made for those in power. That is the reason why these constitutions cannot endure. You know, say for example, our 1997 constitution, within a space of 20 years, 19 years really, went through 83, more than about 86 amendments. That's too much. 20 years. We're talking about the US one, 230 years, 17 amendments. Yeah. So, you know, there's a lack of seriousness there. It's not that we don't know what is right and wrong, but we cannot take public power for our own benefit only. Human beings must know that we are limited in the time we spend here.
But Barrister, in a situation or in a society where people's level of education is too low, it becomes a little problematic to leave these things vague. For example, you talked about freedom of expression, for example. Yeah. But if the Constitution talks about freedom of expression, just like that, crassly, without breaking it down, there is tendency for the illiterate, for someone who really do not understand, to run into trouble.
Well, this is a country. You know, maybe your lifetime is 100 years, maybe 130 years, or 1,000 years, as our Professor President was saying.
Yes.
All right, maybe.
Yes.
But this country, the Gambia, is permanent. As long as the human species are in this world, I am hoping our country is permanent. Yes. So,
yes,
we will learn. If you defame somebody and they take you to court,
you will learn your lesson.
Yes, your business is closed because you need to pay the person $1 million if you don't have it. Your business will close. People will begin to learn. People will begin to take notice. Well, Mr. Njai did this and this was what happened to him. And then they will coordinate their actions properly. So we don't need to worry about whether the people understand or not. They will learn. Look, you know, about 2, 3 years ago, 4 years ago, in this country, even children know that you cannot say certain things.
Yes.
But since the freedom came, people are saying whatever they want to say. And I'll say thank you. And more of that. That is what we want. More freedom. Yes. We don't need to control people. We just need to do the right thing. We need to understand that the country remains. But whoever is ruling us today will eventually leave. It is the law of nature. Nobody escapes that. Yeah.
So, Barrister, you talked about the Gambia there being permanent, being an entity that will remain. So now, and then this new draft constitution is talking about the Gambia as a state, as a country, and the people. The issue of sovereignty, for example, is something that has appeared, that has featured in this new document. But that is this word that has disappeared, the word secularism. The Gambia, I mean, this is a word that has been proved to be very contentious. It has confused so many people. Secularism, when you talk about secularism, what are you really talking about?
Well, it's just like saying, as in the case of the United States Constitution, the state shall not establish any institution of religion. So separation of religion and state. That's what we have to do. Now, people say a sovereign republic. Others say a secular sovereign republic. You don't need the secular there. It's an excess word. Yes.
It's an excess word?
Yeah, it's a word that is excessive. So you don't really need it. Sovereign republic is enough, not
yes.
sovereign secular republic.
Yes.
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 Sovereign republic is enough. It means that the sovereignty of the Gambia resides in the people. That really is what it
yes.
means. So people say to either include secular there or remove secular there, one way or the other, means that you have some particular religious view in your head. It is a secular republic, certainly, whether that word is in the Constitution or not. That is what it means. The Gambia is a secular republic. Now, Muslims may be the majority, and they are the majority. There is no question about that.
Yes.
But we are not running this country on the basis of Islam. We are running this country on the basis of the fact that every person in this country has an equal stake in the Gambia. Yeah, this is why we celebrate Christmas,
yes.
St. Mary Days,
yes.
Tabaski,
Yes.
and all the Eids and other religious festivities.
Exactly.
We want to be inclusive. Religion should not be a dividing factor as far as our public life is concerned. You go home and practice your religion. I go home and practice my religion. When we met in the public space, we met as Gambians, everyone equal to the other person. It is the only way we can advance the public conversations that we are building around the issues of tolerance. I know society can be divided, but it can be divided over irresponsible, unnecessary things.
Yes.
Yes.
Yes. So now let's talk about the issue of enforcement and defense of the Constitution. This very important document. For example, this new draft Constitution talks about every person having the right, for example, to institute legal proceedings if he or she, for example, feels that a part or this document is being violated, for example.
Yes, that is a constitutional right. If you believe that the Constitution is infringed by the government, say, because you see the enforcement of the fundamental freedoms is mainly against the government, but there are other aspects of the document also that can be enforced against the government. Say, for example, the president made an appointment that the Constitution says he cannot.
Yes.
But he went ahead regardless and decide, okay, I'm going to appoint Mr. Njai vice president, even though he knows very well that you have dual nationality. Yes. The Constitution says he cannot do that. So if he does that, you can challenge him. Yes. In fact, talking about enforcement, talking about that, people have a right. That happened during the time of the previous president.
Yes.
They
talking about the Kemes and Jame.
Yeah, exactly.
Yes.
The Kemes and Jame case.
Mm-hmm.
Yeah. So the court said, Section 1 on the nature of the government we have cannot be changed. Yes. That's what the Constitution itself says. So you cannot do it through the normal way. If you want to change it, then you have to go through a referendum. As we all know, the president didn't bother. He just changed it. So you see, we had secular republic there, but it meant nothing. Yeah.
Yes.
Yes. The court said it was sovereign republic.
Sovereign republic.
Yeah, you don't need a secular, it's not part of the Constitution, because you need to go through a referendum.
To really determine that.
Yeah, you need to go to a referendum, tell the people, I want to change Section 1 to a secular republic, a sovereign secular republic. And if they agree in a referendum, fine. If they don't agree, then you leave it as it is.
But the issue of referendum sometimes can also be tricky, because you need to get at least the greater part of the people on board. But how about the minority? Because I think they are also very important. When for instance, that happens and you have two people out of the many people who voted in a referendum say, no, we object to this. What happens?
No, that's, here we're dealing with the democratic principle. Even if it is 99 and 100, under our laws, the side with 100 wins. Yes. Remember, the coalition defeated the former president very narrowly. Yes. Mm-hmm. So, but that doesn't mean that the sitting president is not legitimately elected. So, elections and the numbers are part of the constitutional principle.
Yes. Okay. So now, then let us talk about the other laws of the country. The Constitution is the supreme law, but we also have other laws. Say, for example, Acts of Parliament. You have other laws, for example, customary law, Sharia law. How does this relate to the Constitution?
They must all comply with the Constitution. There is no way around it. If those laws are not compatible with the Constitution,
so they become null and void.
Well, to the existence of the incompatibility, yes, they can become null and void. Yes. Or they become null and void, yes. So compatibility, in fact, that's an improvement on this text. I've seen somewhere that they talk about compliance, but really the principle is compatible. That is, all the laws that come into play must comply, must be compatible with the Constitution. If there is an incompatibility, then that law, to the extent of the incompatibility, is null and void. And that is not the new laws that will be coming in. It's even the old laws that are in the books right now. So the department responsible for that ought to look at those laws and determine, in its professional opinion, whether those laws are compatible with the Constitution as it is. I know there are several laws that are not compatible with the 1997 Constitution. They are still in the books. So that will continue. But of course, there are other ways to do it. Particular lawyers can go to court, with those incompatible provisions in inferior law to say, this is incompatible, I want a declaration of incompatibility, a declaration that is inconsistent with the Constitution, so it's null and void.
But then, Barrister, when this document came out, one issue that proved to be vexed is the issue of Sharia law. There are some people who just about argued that Sharia law, for example, is too harsh, is not compatible with our Constitution, for example.
Yes, but when they say Sharia law, which part of Sharia law are they talking about?
They're talking about the issue of inheritance, for example.
Yes. Well, it is in the Constitution. So, but there is also a section in the Constitution that says that discrimination over inheritance and other things, ought to be stopped.
Yes.
So I don't know how that will work out eventually, because if we will have a Sharia High Court. So if that happens, so I don't know how they merge and rationalize the two. We don't have a Sharia Court of Appeal or Supreme Court.
Yes.
I think the normal channels would go. We have the High Court, but the Court of Appeal and the Supreme Court will remain as it is. I am not sure, because they said that affects only the communities.
Yes.
Say, for example, that are Islam. So that is what those Sharia laws, they apply to the communities that believe in that. So
they're only applicable to
Muslims.
Muslims, yes.
Yes. Yeah, because it says it's applicable to the communities. So the Sharia Code is not going to adjudicate the affairs of Christians. It will be just Muslims.
So how about if it is applicable to just Muslims and you have a section, a quota in the Muslim community who do not really believe in this law? What happens? And you have a constitution which is talking about discrimination, for example, that may prove nightmarish, right?
Yes, but there are exceptions to discrimination. There can be exceptions to discrimination. So I don't know how it will be worked out. But if they don't believe it, well, the Constitutional Review Commission told us whatever is in here came as a result of consultation with the people.
Yes.
I know there are provisions there that are not based on consultations with anybody.
Yes.
It's their own views that are in there. Yes. But nevertheless, whether provisions within this draft constitution came about as a result of consultation or not, if the laws are good, compatible with the values, the principles, the dictates of democracy, freedom, the rule of law, then certainly, yes, we want a document that respects the Gambian citizens. Yeah. So certainly, like I said, as in the case of these particular documents, I don't know what would be said about that. But if the Constitution is adopted, those people who are opposed to that have an opportunity at the referendum. You may say, okay, they don't have the numbers. But if, for example, Sharia disadvantages women, you know women are very numerous in the society.
Yes.
It's up to them. If they believe this is something they can live with, fine. If they believe uniformly that we don't want this, you know, again, they can make their voices heard.
Is that really, does that happen, like the issue of compromise in the application of law, for example?
Well, I think the only reason why, say, for example, no, it's not an issue of compromise. What I was saying is when it comes to the referendum, you know, this is going to have to go through a referendum, and it is going to go through that.
Yes.
So if you don't like particular provisions and you feel very strongly about them, then you have to make your voice heard. That is what democracy is all about. Yeah, women are very numerous. Muslim women are very, very numerous.
Yes.
Yeah.
Yes. So now let's go through this document. I just want us to go through some of the chapters there. Chapter 5, for example, talks about fundamental rights and freedoms. And if you go through that chapter, you come across the issue of freedom of assembly, for example, something that has proved to be quite contentious. You have that, and then the Constitution guarantees the Gambian individual to the right to assemble peacefully and unarmed. But then you have this law, the Public Order Act. So how does that play out? We still have that law, and then we have a document that is also a new document that is talking about people having the right to assemble whenever, or demonstrate, if you like, whenever they feel like doing so.
Yes, yes, but you know, the the Constitution says, excuse me, this Constitution and other laws, that's what it says. I believe the Public Order Act is unconstitutional.
Yes.
Yes, that's what my personal belief is. The Supreme Court decided differently.
Yes.
They believe
that it is
yes, it is valid. It is part of the laws of the Gambia. But many people I know, many people I talk to do not agree with that. Yes. So for me, what matters is ultimately to debate that issue and change that law. The Public Order Act needs to change. It is incompatible. Yes, it is incompatible with democracy. You cannot require people to take permits. And every single day, we are seeing governments, the previous government, the current government, we are seeing them hold meetings with no documents, with no permission, or automatic permission given to them. Why would permission be denied to other sectors within the same entity? Yes.
And if you have our Supreme Court, for example, the highest institution to go to Toronto when things go amiss, for example, in respect of people's rights, and they come out to uphold or to hold that it is part of our laws, it is going to stay. What happens then? Well,
if the government is not properly democratic, because that is usually the problem. And the reason why governments are not properly democratic is because they believe the public space belongs to them. Sitting governments generally believe the public space belongs to them, so they don't want to be criticized, they don't want to be questioned, they don't want to be held accountable. You know, so in a situation like that, what do? Even if there are no security reasons, you deny people permits, you don't give them any reasons. That itself is inconsistent with the rule of law. It's inconsistent with democratic values. And that is why I believe the Public Order Act ought to be taken out of our statute books.
But we live in a completely new environment. We now boast of a so-called democratic dispensation. But and then we have our judiciary, a Supreme Court that comes out to say this is part of our law and this ought to stay.
Well, we are not saying it's not part of the laws. It's part of the laws since it is not amended. But you see, you have to do a synchronization. Here is the Constitution, here is the Public Order Act. Other parts of the world also have their responsibilities as far as public security is concerned. But you see, all they require is advance notice about meetings. Yeah, you give them advance notice and they'll take care of the security
aspects, yes.
Yes, especially when there is no threat of violence.
Threat of violence,
yes. So yes, it's part of the law, but it's not synchronizable with the Constitution. It needs to go, my friend. That is a 19 it's a long time.
Long time, like, colonial.
Yeah, 1963 or something like
yes,
that,
yes.
exactly.
Colonial law.
Yes. So why are you saying that ought to stay when people are not threatening the public security of the country? What is the reason for that? Especially when we see the police refusing to respond to permit requests. They'll deny you without advancing any reasons. All those are unreasonable applications of the law. Yes, you need to give a reason. But you cannot sit on these applications, refuse to give reasons, and then try arresting people and all that.
So then the commitment, for example, we are talking about this current government, the commitment of our government in terms of keeping up with its promise of, us, this country being a truly democratic country where the rights and the rights of the people are respected and protected. That would be thrown into question then.
Of course, that is absolutely in question. Yes. It has nothing to do peculiarly with the current government. It's not peculiar to our current government. When you give, uncontrolled power to politicians, they are going to take that uncontrolled power and run with it. When they believe, wrongly, as in the case of the Public Order Act in relation to the Constitution, that they can stop people. Sometimes the police, we are blaming the police because the police are the implementing authority of the Public Order Act. Yes, yeah. But the police is not a free institution. Yes.
It's also bound by the Constitution, bound by the laws.
Yes, but when I say it's not a free institution, I mean the police as of now, from the time of the Jawara government to now, the police are in the hands of the government. The Inspector General of Police is not independent. Yes, on operational matters maybe, but even in contentious operational matters, they don't have the freedom. Because the president can dismiss you
and then they can call you and ask you to do A, B, or C.
Absolutely, yes. So I think our institutional structures are faulty. And this
constitution is also talking about giving the power to the president to appoint the Inspector General of Police.
Yes. That is still in the Constitution. Someone has to appoint.
Yes. So someone has to appoint.
Someone has to
But
appoint.
is there a way of restricting that?
Yes, it is. It is. Right now, if you want to remove a certain level of official, certainly you have to go through a different process. So the president cannot just write a directive on a plain piece of paper to the Inspector General of Police and say, get out of here. You are no
that
longer,
has to go through processes.
Yes, that has to go through processes. If you have a reason to do it, you advance that reason, then a committee would be set up and look at it. If they feel that you have legitimate reasons, then probably the Inspector General of Police can be removed. But other than that, we want to make it impossible for our politicians to do these things. But then the document itself must demonstrate fidelity to the rule of law.
Okay, so now let's quickly go through some of the issues that are being touted by this constitution. For example, let's say the issue of absolute majority, 50+1. This is something that will just about turn the table in respect of the country's political future. But what has obtained in other crimes is that that can also lead to court cases. From a lawyer's point of view, for example, the politicians would be running to court to seek for interpretation to seek for a redress in respect of the elections. From a lawyer's point of view, do you think absolute majority is the way to go?
Well, personally, no. I believe first past the post is good enough. Our problem is not about whether you are representing a majority as in terms of 50% plus. No, our problem is the issue of governance itself. We've never managed to govern this country properly. Yes. Even some people would reminisce nostalgic about the First Republic. I lived through the First Republic. Yes. I went to high school during the First Republic. So it was not like we were not aware of what was happening. It was terribly incompetent government. Yes.
But some people, bad governance, some people would pin it on the issue of, longevity, on the issue of having presidents for life, someone in office for decades. And now we have this new development. Now, do you think that's the way to go in terms of the term limit that is being talked about?
Oh, certainly. The term limit is an excellent idea, but that, of course, is something that the whole country embraces. So it's not the Constitutional Review Commission that brings that into the statute. Like they bring a lot of things here and tell us it's the people.
The people, yes.
No. But in terms of term limits, yes, there is a consensus about that. We don't want lifetime presidents. If you don't have anything to do with your life after 10 years, that's up to you. Go home, live on your pension, and enjoy yourself. Yeah, we'll give them generous pensions, but we don't want them hanging around forever until you can't even work. What kind of leadership is that when you are not even awake to your responsibilities because of old age? Yeah.
Barrister, this constitution talks about rights and it affects all Gambians, and then every Gambian shall have a right to vote. That is one thing that has been guaranteed by this constitution. But how about our prisoners? These are people who do not vote. How about that?
Well, that is a contentious issue. I can see that becoming contentious in certain quarters. And remember, the younger generation is fairly progressive. But the older generation is very conservative most of the time. You know, some people would think if you are in prison, you must be a bad person. Not really. Not really. It was a prison situation, I say, that changed this country. We are in this republic today, this third republic, because of, you know, people who ostensibly broke the law and were sent to Mile 2. That galvanized the country, woke the country up to its realities. And that is why we are here today. So I don't know how it should be done, whether they should all be allowed to vote or whether particular sections of the prison community should be allowed to vote. But if you ask me, the prison community is not too large. Yes. I will ask them. I would allow them to vote. They are still Gambians, notwithstanding the fact that they probably made some mistakes in their lives, and they are serving time for that. But that does not remove their citizenship from them. So we are talking about citizenship.
So should this be, should this affect or applicable to just certain crimes or across the board? Because some crimes are pretty serious, grave.
Well, you are still a citizen. No criminal activity removes your citizenship from you. So if the Constitution says citizens, there is a strong argument to say certainly under human rights principles.
That has to every citizen,
yes,
regardless of the offense.
Wherever they are. Yes, wherever they are, whether they are in prison or wherever. Yes. You know, we need to, you know, every society would have its, towering intellectuals, their presidents, But every society must have a combination of different sets of personalities for that society to fulfill its dreams. Yes. You need people who sweep the floor for you to come and sit here and present your program. You wouldn't like to be told to come and clean your your floor and then come and present it. I don't think you would like it. But no, I would say give the vote to the prisoners.
Of course. So, Barrister, you mentioned something that is very interesting, the issue of the younger generation being quite progressive when you have the older generation that is conservative. And if you look at the composition of our Supreme Court, for example, almost all the justices are at least 60 years old. So how do you reconcile that? Because one may argue that these are conservative minds on our Supreme Court. How do they keep pace with current realities in respect of how the younger generation think and see things?
Well, I don't think age itself. There are people who are very young and they are conservative also. Mm-hmm. Yes, yes. I mean, sometimes when I hear some young people speak, I wonder, you know, are you a reincarnation of some person
70
who was
or
80, 90 years old? Yeah. No, but yes, the Supreme Court, I don't think everyone on that Supreme Court is 60 years, but yes, most of them are over 60 years. The vast majority are over 60 years. But you don't.
So the younger generation have faith in these people?
Yes. You know, age has nothing to do with your mindset. If you believe in the values of freedom, if you understand truly the values of your calling as a lawyer, as a judge of a superior court, and the most superior of them, really, the Supreme Court, yes, age should not be a barrier to doing what is right. Age shouldn't be a barrier to that at all. You know, we assume that they went through a very rigorous training, that law is about the values of freedom, about the values of the rule of law. So even if you disagree with people, even if you don't like people, but if they are right, you cannot take their rights because you have the authority, you have the power to do that. Yes.
And one event where people, a lot of Gambians try to, I mean, you know, analyze or assess the mindset of our Supreme Court justices has to do with the Yakumba Jaite president or government injunction there, the injunction that was thrown out by the Supreme Court.
The injunction.
What did you make of it?
The interlocutory injunction application.
Yes.
That was disallowed. That was not allowed by the
Supreme Court. Yes.
Well, I believe the court was wrong, and I wrote about that.
Okay.
Yes.
Why did you hold that position?
Because this was not the substantive matter. It was just an interlocutory application.
Yes.
Yakumba Jaite was simply saying, allow me to continue until you make a decision.
Yes.
That was all. Yes. And according to the law, as it is today, I believe Yakumba Jaite should have been allowed to continue. Because he was serving in that position. Yes.
That was a complex event, Barrister, because soon after Yakumba Jaite was sacked, someone was nominated to take her position, to step in her role, and that person was nominated by the president. And the president, some would argue, is the face of the state, acts on behalf of the state. So some would say, I mean, life must continue in respect of the state.
No. When it comes to human rights, the rights of one person is as important as the rights of the state. In fact, this is what human rights is all about. It's not about the collective, it's about individuals. The president cannot do certain things. The law binds him as it binds you and I. Yes. So, he was the one who nominated Yakumba Jaite. There was no argument about that.
Yes.
Yes. But he didn't have the authority to remove her. It's a very...
But that also is a very contentious issue. How can I have the power to nominate or to appoint you, but I will not have the power back to remove you,
yes,
barrister?
Because they said, the Constitution itself said, that members of the National Assembly are not public officers. So once they are in position, remember, we're talking about the separation of power here.
Yes.
This is a sacrosanct principle in democratic societies.
Yes.
That value cannot be compromised because the president felt he was offended by a member of the National Assembly. Power is about restraint. You need to restrain yourself.
But then do you think that is that would amount to an aberration then? Why would the president have the power to nominate where he doesn't have a say, to nominate someone where he doesn't have any power at all? Say, for example, the National Assembly. Since there is this issue of separation of power,
yeah,
you have the National Assembly that is as powerful as the executive. Why would the president have the power then to nominate someone who would support or act on his agenda at that particular branch or arm of government?
I told you, I said before, our institutions were not developed. Our presidents were not looking at the national interest.
Yes.
They were looking at their own particular interests.
Yes.
Because otherwise, somebody should have said, now this is a colonial, aberration. We shouldn't allow it in our current constitution. This idea of nominating somebody for the National Assembly is nonsense. I'm glad it is now removed.
Yes, by this new draft constitution. That is one of the welcome developments there.
Yes, I think that will stay. We cannot say the president should have that power back. There is no reason for it. You give the president 5 extra votes for nothing. And the worst thing about it is the constitution then dictates that out of those 5 people, the speaker and the deputy speaker must come from those 5
From those
people.
5 people, yes.
What kind of behavior is that?
Does it make sense at all?
No. It nullifies the democratic principle. That's what it does. Yes. The people's voted National Assembly members are in the hands of the president's people. Can you imagine that?
So, barrister, would one be right to say that the Yakumba Jete President Barrow injunction there, the Supreme Court acted along conservative lines? Because in this country, what we know is that, well, someone in position of authority should be respected, or someone in position of, or an elder, for example, should be respected. So a child must not act in a certain way. If you do, the punishment, even if you are in the right, elders are more sympathetic towards the elder or the person in authority.
So
is that the case here?
Who is the child then?
So in this case, we would say Yakuma Jeta is the child, and then you have the president who is the elder, and then who is in the position of authority, position of respect, position of honor. So the Supreme Court naturally acted along conservative lines, how Gambians think.
Well, position of respect and honor, that really cannot be automatic. We now know very well that our State House and other parts of the executive arm of government were used daily for criminal behavior.
Yes.
We know it, but people think we were just been, too critical of that government. But now it is known. So what honor are you talking about? Honor is not in your position. I have this Ustaz friend. I used to tell him, I said, Ustaz, I'm not taken in by your dresses. I look at the character of a human being. That is more important than what you wear. Yes. So president or no president, you must abide.
Doesn't really matter.
Yes. Yeah. So, of course, the president is younger than a lot of people he employed.
Yes.
So if he enters into a dispute with those people, are we going to say they are wrong? They are right because the president is younger than them? The president can be right. But I'm saying, don't give somebody the right simply because of their age or their position. Yes. If you look around the world, you study history. Yes. I'm a historian. Yes. I'm just in law for other reasons. You read but history is what I studied.
Yes.
Yes. So certainly the fall of great men in public, private religious life.
Yes.
it's all due sometimes to serious character flaws there. And these people have millions of followers. So no, I would say, whether you are president or whatever,